Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court of India will be constituting a larger bench to consider question of whether violation of principle of natural justice, particularly audi alteram partem, at the original stage stood cured at the revisional or appellate stage. The division bench of Justice J.K. Maheshwari and Justice K.V. Vishwanathan delivered a split verdict while considering the said question, since Justice Maheshwari answered the said question positively while the same was negated by Justice Vishwanathan. The Supreme Court has clarified that the questions of title could only be determined by civil court of competent jurisdiction. The division bench of Justice Vikram Nath and Justice Satish Chandra Sharma further reiterated that revenue records are not document of title and that the finding during revenue proceedings do not confer any right, title or interest. It was contended that the underlying dispute as civil in nature, which was already adjudicated in respondent's favor. In addition, the FIR premised on the suit property belonged to the state of MP, which was no longer valid as per respondents. In a major ruling, the Supreme Court has recognized the right to a healthy environment free from adverse effects of climate change as per the Constitution of India. The bench comprising of CJI D.Y. Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra recalled the court's decision in M.K. Rajneet Singh versus Union of India regarding blanket prohibition on overhead transmission lines and constituted another expert committee to strike a balance between environmental conservation against climate change and sustainable development. The court emphasized on the state's duty to take care of citizens to prevent harm and ensure overall well-being, which also includes the right to a healthy environment and clean environment. Reference was also made to the preamble of the Paris Agreement in this regard. Further, international obligations to combat climate change were pointed out while advocating for renewable and sustainable resources of energy with a focus on solar energy evading coal-based fuels. The Supreme Court has delineated provisions related to the confiscation of case of property under the Gujarat Prohibition Act 1949 and the Code of Criminal Procedure 1973. The division bench of Justice Velant Trivedi and Justice Pankaj Mittal upheld the Gujarat High Court's dismissal of applications seeking release of confiscated vehicles, stating that invoking Article 226 of the Constitution of India was uncalled for when there were specific statutory provisions available for the remedy before appropriate courts. The Supreme Court has observed that voters do not have an absolute right to know about each and every asset of the candidate fighting elections. It is not an absolute right for any voter to delve deep into the private life of a candidate, and each and every disclosure has to be of such nature which will impact the voting, the bench of Justice Aniruddha Bose and Justice P.V. Sanjay Kumar said. The top court said that the candidates have the right to privacy regarding matters which are irrelevant to the candidature for public office. Now let's have an overview of high courts. A woman living with a man for a considerably long period of time is entitled to maintenance on separation even if they were not legally married, the Madhya Pradesh High Court has ruled. A bench of Justice J.S. Ahluwalia made the statement while dismissing a petition by a 38-year-old man who was ordered by the trial court to pay a monthly allowance of Rs 1,500 to the woman he had lived with. The single-judge bench of the Andhra Pradesh High Court has held that Section 152 CPC not only decrees, amendments even to the documents anterior to the suit can be made as long as there is no dispute to the identity of the property and a separate suit was not warranted. It was also furthermore noted that the object of the trial court should always be to see to it that the decree is carried out in order to give the trial a sense of sanctity as opposed to rejecting the applications and impeding the decrees and the process of trial. The single-judge bench of the Tripura High Court has held that sanctioned vacant posts should not be continued to remain vacant for successive years in the absence of availability of suitable candidates in certain categories of the posts. The court observed that if qualified applicants are not available for a particular category of post, the sanctioned vacant positions should not be allowed to stay vacant for successive years. The Calcutta High Court has held that a review application filed under Order 47 Rule 1 CPC cannot empower a court to exercise its inherent jurisdiction to interpret its order. While disposing of a review petition, the court held that it decided the issue by passing the specific order. If the matter is now to be considered under this review application, the matter has to be decided on merit again. Moving on to international news this week. In a landmark ruling, Europe's top human rights court has declared that the Swiss government had breached its citizens' human rights by inadequately addressing climate change, a landmark ruling poised to shape forthcoming climate litigation. It is clear that future generations are likely to bear an increasingly severe burden of the consequences of present failures and omissions to combat climate change, the court said in its ruling. The decision favoring over 2,000 Swiss women who initiated the case is expected to reverberate throughout the European courts and beyond, encouraging more communities to pursue climate-related lawsuits against their governments. The top court in United States, Arizona, a key presidential election swing state, has ruled that a 160-year-old near total ban on abortion is enforceable, meaning that doctors performing the procedure could be jailed for 5 years. The legal ruling triggered major political shockwaves, ensuring that the deeply divisive issue of reproductive rights will feature heavily in November, when Arizona will be one of the states President Joe Biden and the Republican challenger Donald Trump both have a good chance to win. Ex-owner Elon Musk has called for the resignation or removal of a Brazilian Supreme Court justice whom the billionaire entrepreneur accused of censorship for blocking accounts suspected of spreading disinformation. A divisive judicial figure, tyrannical to some and a fervent defender of democracy to others, Maurice is one of the 11 members of the Brazil's High Court. He also presides over the country's Superior Electoral Tribunal or TSE. Critics, now including Musk, have said that Maurice is part of a sweeping crackdown against free speech in Brazil. In the end, we have miscellaneous news. The Supreme Court has voiced concern over the misuse of social media platforms with the posting of messages, comments, and articles on sub judice matters. A bench of Justice Aniruddha Bose and Justice Belaam Trivedi made the observation while initiating a contempt action against Assam MLA Karimuddin for his misleading Facebook post regarding a case reserved for judgment. It is a matter of serious concern that nowadays there has been a profuse misuse of social media platforms on which messages, comments, articles, etc. are being posted in reports of matters pending in court. Though our shoulders are broad enough to bear any blame or criticism, the comments or posts published in respect of matters pending in court through social media platforms under guise of right to free speech and expression, which have the tendency to undermining the authority of the courts or interfering with the course of justice, deserves serious consideration, the bench said. The Consumer Affairs Ministry has directed all consumer courts to start hearing cases online from 15th April. The National Consumer Dispute Redressal Commission (NCDRC) has released standard operating procedures for these hearings. The NCDRC is the apex appellate body of the Central Consumer Protection Authority (CCPA), which reports to the ministry. The decision is expected to make it easier for consumers to resolve their complaints and save them time and money. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.